Day afternoon, the 27th of February, and we are now going to take up H-193, a new bill, and going to start with the walkthrough, and then we have some witnesses. Over to you, Ben.
Great, thank you, Bill. For the record, Ben Novogratski from the Office of Legislative Counsel. Before the committee is H-193, entitled An Act Relating to a Child and Parent Legal Representation Working Group. So the 10,000-foot view of this bill is that it creates a working group to essentially design a system to provide legal representation for both parents and children who are involved in the child protection system. With that, I'll go into the bill. In section 1, subsection A, with the creation and establishment of the committee, it will be called the Child and Parent Legal Representation Working Group. Very creative title, if you ask me. And it's to design and propose an interdisciplinary model of legal representation for children, parents, custodians, and legal guardians involved in the child protection system. The membership of the group is composed of the Chief Justice of the Vermont Supreme Court or his designee, 2 current members of the House, not from the same political party, who shall be appointed by the Speaker, 2 members of the Senate, not from the same political party, appointed by the Committee on Committees, Defender General or designee, the Commissioner of DCF or designee, the Child, Youth, and Family Advocate or designee, a representative from Voices for Vermont Children, a representative from the Vermont Parent Representation Center, and an individual with lived experience in Vermont's child protection system who is represented by the Office of the Defender General, who shall be appointed by the Defender General. I just want to take a moment to pause that I've received inquiries from other groups that want to be involved, specifically the Department of State's Attorneys and Sheriffs. The Executive Director reached out personally and requested involvement. And I've heard through the grapevine that there may be some others as well, but I will leave it to those witnesses to suggest those. So any questions on the current makeup before I get into the powers and duties of the committee or of the group?
Yeah, go ahead, Jack.
This is just a simple question, I think, but why can't we just form this working group outside of status? Like, why do we need a bill to form this working group? Why can't we just get a group together to say, this is the problem, here's the solution to fix it, and get together outside of?
I mean, a lot of times working groups are created so that you have something in session law that you can point to. It outlines the kind of direction of the group. And as you'll see in this bill, provides some compensation for those individuals that may not be otherwise compensated.
Compensation for those involved with
the working group.
Mm-hmm. So this is. So it's 18,000. Well, we'll get there.
We'll get there.
Yes. Yep. I'm definitely have questions on that.
Sure. Any other questions on the parts that we've gone over so far? Okay, so getting into the powers and duties. So the working group is charged with the study and to form a design of that system of child and parent legal representation for use in our system. It shall be consistent with the recommendations contained in various studies. The study of Chin's case proceeding in Vermont, which was authored by the National Center for State Courts in 2021. Caseload recommendations identified by the ABA and the Children and Youth Services Review's 2020 study entitled Understanding the Effects of an Interdisciplinary Approach to Parental Representation and Child Welfare. So those will form sort of the basis of the group, their working knowledge, if you will. And then the group's study shall focus on 1, identifying the appropriation to the Defender General for representing these individuals, looking at what the average compensation level is for attorneys employed by the AG, Defender General, the state's attorneys, or those that contract with those agencies to represent children and parents in Chin's proceedings, and the average compensation of social workers employed by DCF and contracted social workers with the Defender General. They're also supposed to look at anticipated costs to provide legal representation in child abuse and neglect substantiation appeals. recommended compensation levels for attorneys and social service personnel who represent the individuals in the system. Any estimated federal funds that can be leveraged to support the system. And then at least one recommended structure for the administration and operation of an interdisciplinary legal system. And then finally, the number of children under state custody who are eligible for Title IV-E funding and the percentage of those children represented by the Defender General. So that's a long way of saying that's the focus of the group in their study and design. The group shall have the support of the Office of Court Administrator for technical, legal, and administrative assistance. They're also permitted to consult and seek assistance from child protection experts it deems necessary, including the ABA Center on Children and the Law, and then the New York City Center on Family Representation. A report from the working group is due December 15th of this year to this committee, the House Human Services Committee, and then the equivalent committees in the Senate. The report must include a proposal for administrative programs providing the interdisciplinary approach that are separate from the system of criminal defense provided in CHIN's proceedings, a proposal for a source of revenue and appropriation to support the system, and then a plan to use those Title IV-E funds to support the proposals as well. Proposed standards and performance measures for attorneys and social workers involved in the system, requirements for training, supervision, and performance monitoring to ensure competence and effective representation in services, and whether the Office of Child Representation and an Office of Parent Representation should be established as independent agencies within the judiciary or in any other form. The meetings, excuse me, the Chief Justice calls the first meeting on or before August 1st of this year. The Chief Justice shall be the chair and may designate a member of the working group as co-chair if necessary. Majority is quorum. Working group ceases to exist on January 15th of next year. There is a compensation and reimbursement provision. So there's the standard reimbursement and per diem compensation calculations for legislative members for not more than 10 meetings. So while there isn't a cap on the meeting specifically, you're only going to get paid and compensated for 10. And then it's, those are paid through monies appropriated to the General Assembly. And then other members of the group are entitled to per diem compensation and reimbursement for not more than 10 meetings. The payments are made from monies appropriated to the Office of the Court Administrator. And then these are supported by an appropriation in the sum of $18,830 to the Office of Court Administrator from the general fund in fiscal 26 for per diem compensation and reimbursement for members of the working group. And then it takes effect on passage.
So you probably don't have this information. I'll ask you anyway. So how much of that amount is related to the second item as far as the per diem compensation as opposed to the legislators?
I did the math myself. I just don't know if I have my calculations in front of me. But the majority of the amount goes to the non-legislative members.
The non-legislative members. So those are all except for the individual with lived experience.
Well, legislative meaning the members of the legislature.
Oh, most of it's for the members from the legislature.
No, who are not members of the legislature.
But that compensation would then only be, don't we normally, if it's like a commissioner or a defender general or designee, that as long as their state are, they're employed by the state, we don't pay extra?
Yeah, we have there are bills before the committee right now that have that language in it, but this language is not that.
And that's where the 18,000 comes from.
Right. Oh, it's calculating because there's a JFO formula to calculate per diem compensation and then another one for reimbursement. So using those calculations is how we reach the for 10 meetings. I think it's like $50 a day in either compensation or reimbursement. There's a different amount. And then, yeah.
All right. So this will be a question I'm going to have for all the witnesses. is why we need that, because I'd rather go to if they're already getting paid, then that's fine. The second thing I will ask the witnesses is justify for me why we need four legislators on there, because I think we shouldn't. So those are the questions just to put up right up front as a couple of the questions that I have on that. So not for you, but I guess while I was on that, wanted to make sure that was out there. Yeah.
Yeah, and I had those same concerns, because I just assumed like the chief justice, the defender general, the commissioner, children and families, advocate for, child youth, a representative from Voices for Vermont, and a representative for Vermont Parent Representation. I just assumed they.
Right. Number 9, I agree that the individual with lived experience,
Oh,
that person
definitely.
would have to get per diem.
Yeah, and even the members of the House or Senate, I mean, if they happen to meet during the session.
Well, yeah,
They'd be-
Yeah, but, and there is language that limits it to just if they meet during adjournment.
Right.
Okay.
But I don't think we want, I mean, there's a general, we don't want to have legislators on study groups as much as possible. So just want to put that out there. Tom?
Sir.
The first thing that jumps out that I would need to ask, I guess, is I understand the statement or the purpose of the bill. Why do we have to do that? Where are we lacking? What's going on, I guess?
I would defer to the witnesses
okay.
on what the kind of state of the system is, and the rationale for the bill.
Okay, all right. Well, obviously, because you decided to go.
It's just not my place to
Right,
say.
all right, I got you.
Ian?
This is my first working group bill. So I'm just curious, I have one question. Thanks. It's a big day. Is it fairly common to link working groups to recommendations from other studies, like in subsection C on page 2?
I mean, kind of tying it as the kind of foundational work. I can't say one way or the other from personal experience.
Yeah.
It's the first time that I've drafted such a language. But I can't say if it's usual or not.
Yeah, I was just, and I guess I'll save it for the witnesses if they feel like that would be like restricting or if that's actually good guidance. But okay. Cool. Thank you.
All right, good.
Yeah,
Oh, yeah,
I guess I'd go right back to the comment you made about having members of the House or Senate even on these committees. And I don't even know who to ask. Why are they included in here, I guess?
We can ask the various witnesses and if they don't know, we can ask the sponsors.
Right.
Of the bill.
Right.
I think that it has been kind of a practice for these kind of things in the past to put legislators on, but they're trying to shift that practice.
Okay.
I think
And my guess is they have 2 weeks just because they want it down.
Yeah. Yeah, thank you, Chair. I think, and just like a broader question that I had is, was this legislation designed with legislators in mind who they want on this working group?
I can't say.
I know, and it's just like a question worth asking because it seems very intense. Like I would have really strong reservations that if any of the sponsors would be recommending themselves for compensation on a committee that they're creating.
Yeah.
I mean, that's just like, that's crazy. That's really crazy. So I think there should be language barring any sponsor of the bill to be included on the committee. Oh, no, I'm very serious. I'm not saying.
No, but that isn't.
Like, I
just don't think
because I
there should
think
be
it's a deliberate
legislators involved.
conflict.
Right.
Yeah, well, I agree with you 100%. There shouldn't be any legislators. If there are legislators, we need language saying that the sponsor should not be allowed on the committee itself.
It's probably an interesting conflict there.
Yeah, well, that makes a lot of sense.
They're creating legislation to compensate themselves.
I mean, it makes sense looking into because it's not necessarily, I mean, if it's the speaker who is designating somebody, then it's not like that individual is, putting the bill in so that they are going to get paid for something.
So I do think there's an undue expectation of pressure even on the speaker herself. To
No,
a point, I think there's,
you know,
objectively, there's a perception issue.
yes. I agree with that part. There is a perception issue, but
Yeah.
I don't think
I mean,
it's
it's like
really truly a conflict, but it doesn't matter because I want these legislators unless I'm
Yeah.
really convinced.
Off entirely, yeah,
Convinced, so this, so,
definitely.
Let's keep arguing about it.
No, I agree. I agree.
Because they're arguing if they stay on.
No, I agree with you, Martin. I mean, I agree that there shouldn't be any legislators on it.
But I'm giving everybody a chance to convince us otherwise.
I'll give you a chance.
Yeah.
Right.
Thank you, Ben.
All right, thank you, Ben, and we'll start with Judge Zona.
That's like, grenade, walk away.
Exit stage.
Being a little instigator over there. Good afternoon.
Good afternoon.
Tom Zonay, Chief Superior Judge. I did visit with the Chief Justice because he was named as the individual who would be working on this.
Oh, yeah, Representative Arsenault has a question before we get started. Somehow I missed that. I didn't realize you were not at the airport.
I will be soon. But I just wanted to offer that oftentimes legislators who are sponsoring bills are doing so because they have, a vested interest in outcomes and an interest in the subject area and sometimes a lot of experience in the subject area. So I think it presumes a lot to say that we would make any kind of blanket rule that if you sponsor a bill that involves a study committee, you couldn't be on the study committee. That just seems counterintuitive. I understand the perception issue, but I think that would be it could be really limiting as far as like the expertise and interest that is brought to any working group.
Especially if we get a bill with about 100 sponsors and that limits that. But it's a non-issue, so we're gonna proceed. And we'll have the argument if there are gonna be legislators.
It's not gonna be.
So Judge Zone, because I know you have a hard stop very soon, so.
So I spoke to the Chief Justice and I am authorized to say that he supports this and if nominated, he will serve. I think that's not the expression. He did have a couple thoughts about, I think, as Ben was talking, the makeup of the committee. Since the court administrator is going to be an integral part of the administration of the committee itself, and the fact that when you look at any type of system for representation, it's going to involve interaction with the courts. Chief thought that it might be helpful to have the court administrator or designee as a member of the committee.
All right.
He also thought that it might be helpful to have a trial court judge perspective because they are dealing with this on a daily basis. And he did what the original bill didn't say. And I took that deep breath and went, whew. He suggested it might say chief superior judge or designee.
In addition to him?
In addition to him, for the trial court perspective, because his thought was that we get more perspectives. And I've already heard the Department of State's attorneys, that was the other idea, to see about that, because those are the entities who have the daily interaction and work with the group who is supported by attorneys. The one question that was asked that I did note, and it's on page 2 on line 15 about the powers and duties where it says the working group's design shall be consistent with. Essentially what that means is you are correct that the design, you're having guardrails, that the group starts out knowing we need to stay within these parameters. That's a policy decision. If you wanted to say the working group shall consider, in making recommendations, whatever the working group shall consider, that leaves it more open. But that's a choice for the legislature. If you want to control kind of and put the guardrails up for keeping something within it, the language you have does that. If you want to make it wide open and say, we want to hear what the working group has to say, we want to make sure you think about what's in these reports, you might want to just say shall consider.
We'll ask the other witnesses on their preference on that as well.
But those were the only and I think your other question was about payment, and any of the judiciary personnel certainly do not get a per diem.
Okay. Any questions for Judge Zone? Yeah, go ahead.
Just a question. Per diem, that also includes reimbursement, right? Like when we it's combined. Like when we talk about per diem and reimbursement, it is one and the same. So would-
per diem would be like a $50 payment per day. Reimbursement would be for any food or.
It's like, for example, if I had to travel to Burlington and get a hotel for the night, that would be covered by this reimbursement.
I think there are restrictions on the level of reimbursement, but yes, they're like.
We'll take, I mean, I don't want to go down the rabbit hole, but
So, okay, so reimbursements like mileage, it's something that,
I don't know that, I can't think of ever putting in on a work group for mileage to the, if it's part of the bill, it's part, I think that when we do work like this, it's part of our job in the judiciary.
right? And I think that's usually the case with entities that are already being paid. It's the individual who's getting per diem will also be.
Yeah. Working on these committees, in my assessment, again, it's part of our job that we work in the judiciary for.
Ian, then Ken.
so.
No, sorry, he was getting, sorry. Go ahead.
Sure. Have you served on a working group before?
Yes.
I have just one. I have a question, only because it came up in H44 discussion as well, about just the number of individuals on a working group and what number is like the most effective number. And I understand that people's experience and where they touch the issue matters quite a bit. But I was just wondering if you had any thought on if there's sort of like, it gets to sort of like a level where there are too many people.
I think it really depends on the subject matter. For instance, the Sentencing Commission has about a dozen members and, I chair that. I actually think that's a good number for what we talk about and the way we deal with it. I'm on other work groups where there are 5 of us or 6 or 7, and those are good numbers. I can't say that I've been on a work group and thought this number is just unwieldy. I believe it could happen, but I personally cannot say that any of the work groups that I've been on, I've ever thought that.
Oh, that's really helpful.
I think we're talking about 10 people at this point, if we add the 3 and take out the legislators.
Which is way less than at least one other.
20 some odd.
Yeah, yeah.
Okay, Ken.
So just so I follow this properly. So like when we're serving on the judicial nominating board, this is completely different.
Yes.
Expenses, all that stuff, right? Because I know when you're on the JMB, if people want to stay overnight, they stay overnight and that's paid for. And I believe meals and all that stuff.
And this isn't the kind of working group, I mean, that's a
That's
different kind of
right.
animal, yeah.
Okay.
Yeah,
That's all I want to know. Thank you.
Anything else for Judge Zonay? Not seeing anything else?
I-
Yeah, go ahead.
Just,
Yeah, go ahead.
and again, this just goes to broader intent behind this group. Like, do you feel like this is something that needs to be derived out of a bill coming before the legislature? Or can't this great work and these important causes be addressed in a private setting? Outside of.
Yes, it can be addressed. We could get a number of people together and say, let's all get together and talk about issues. And we do that in a number of areas.
Right.
I think when you're looking at a bill like this and you're looking at these issues, formality and the guidance and the structure, I think do help. Look at the issues that you're going, because I think it puts everyone on the same page, recognizes that we're doing this because the legislature wants to hear from us. If I put a group together on the side, I think that there's a perception that, well, we're just talking and whether they listen to us or not. Here, it's a public group. Everyone, the legislature, the citizens know this is an important issue that the legislature is putting out there so people can address. And the work that's done is filed in the legislature with a required report. It's a public report, everyone can read it. So I think there are certain areas such as these types of important issues that have been, as you note in the section here about the prior reports that have been building that need that, I would say, the formal approach as opposed to the go figure it out and come back to us. We do that every day on bills. We don't need working groups when we go out and talk about trying to resolve bills and issues like that. But when you're dealing with these types of issues, I think the formality and the transparency of who's working on it, how it's being worked on, how is it set up, I think that can help.
I appreciate the perspective.
Thank you. Appreciate the time. So thank you, Larry, Chris, thank you for being here, Larry. Nice to see you again.
Why didn't you guys ask him the really hard proposal before?
I was the opening act.
Take care.
Wait for you, Larry.
I was afraid of that.
Thanks for being here.
Just so you know, the first committee I appeared before here in Vermont and the first study group I was on was the same time I had a full head of hair. So that was a number of years ago. For the record, I'm Larry Christ. I'm the executive director of the Vermont Parent Representation Center. I know a few people in the room. Most of you I've never really worked with in the past, but
So why don't we go, since we have a couple new individuals on screen as well, why don't we go around and introduce ourselves? So you have a little more perspective on that. I'm Martin Malone, representative from South Burlington. Been here, this is my 6th term, and I'm currently the chair.
Ken Goslant, from Northfield and Berlin. 4th term.
Karen Dolan from Essex Junction. This is my 3rd term, my 2nd term on Judiciary.
Tom Oliver, Sheldon Swan, and then my 2nd term.
Alicia Malay, Pittsburgh Proctor, 1st term.
I'm Ian Goodnow from Brattleboro, and this is my 1st term.
Zach Hart from Castleton, my 1st term.
Tom Burnett from West Rutland, in my 8th term and my 6th term in here.
I had a full head of hair as well when.
I did.
We have one more person online as well. Go ahead, Angela.
Hi, Larry. Angela Arsenault, representative from Williston in my 2nd term.
Hello.
All right.
By way of introduction, the Vermont Parent Representation Center is a very small organization. It was founded in 2009 to work on this issue. And I was not the first executive director. The first executive director was my predecessor, a woman by the name of Trina Beck, who was a practicing attorney and a magistrate. She and several other individuals formed a nonprofit because it was clear to the people who were working in the child protection system that that the issue of child and parent representation needed reform. It needed work. We have been using basically the same system in the state for about 40 years now. And I want to sort of preface my presentation very briefly with, I've been in Vermont for 40 years, 25 years as a manager in state government, been a division director, I've been a deputy commissioner, I've been a commissioner, been fired a couple times, I've been rehired a couple times. And I also have been the executive director of the Vermont and New Hampshire Upper Valley Red Cross, and have been in this position as the executive director of this small organization for about 8 years now. It was supposed to be a 2-year gig. Now I'm in my 8th year of the 2-year gig at this point. But my role in this process is this organization that I represent, it really doesn't get anything out of this bill, except the satisfaction of knowing we have fixed a very long-standing problem and fixed it in a way that is a win-win-win across the board. The question was asked, could this just be done, with a private group of people or a group of people getting together outside of a bill, outside of the legislature? People have been getting together outside of the legislature on this issue since 2018. I presented the first report to the legislature in 2018, identifying exactly the same things that you're looking at in this bill today. The question was, well, that's only one study, Larry. We probably need to have more studies. We could look at this study. We could look at this study. We could look at this study. And we could look at the very first study. We've studied this thing to death. What we have not had is we have not had the leadership to actually take the issues at hand, take the solutions that are clearly evident now, and I'll explain why they're so clearly evident, and put them into practice. That's what we're missing. And that's the reason there's a bill in front of the legislature now to make it happen. Without a bill, we're going to be sitting here 10 years from now having the same discussion. And over that period of time, we will have left about a little less than $2 million a year in federal money sitting in Washington, not in Vermont. Because what has changed since the first proposal was presented is that the Federal Bureau for Children has determined that in addition to funding sort of the more prosecutorial side, the courts, the state's attorneys, some DCF functions, instead of only funding those, the federal government should also be matching state money with regard to parent and child legal representation, which, by the way, is entirely general funded in Vermont. It is not used for match. It's not used for anything else. It's just paying for services. The reality is, in my role, I've reached the point, and I've reached that point in life as well, that I'm not going to come in here and say nice things about our current system. I'm not going to say bad things about people in the current system, because this isn't about people. This is about a system that has failed us for a long time. And I'm going to be frank in the failings that are there. So the reality is that we spend, and I can't even tell you how much, because what you'll have to find is that's one of the outcomes of this working group. It is not a study group, folks. All the studies have been done. And as you will hear from a later witness, these are just the Vermont studies. There's a stack of federal studies like this that identify a better way to do this work. The issue at hand is the fact that the representation of children and parents in family court or CHINS cases, child in need of services, is done primarily for parents by the state through the Office of the Defender General, contracting with private attorneys, primarily solo practitioners. They have been underpaid for 40 years. They continue to be underpaid for 40 years. You cannot make a living in this state being a child protection attorney representing parents and provide effective legal representation. You cannot do it. You will go out of business. You will close your office. The solution for that, and for people who want to do this work, is to take more cases. The more cases you take, the less time you have to work with your clients. That system has gone on for so long now that people think that's the norm. It's okay. I doubt that there's anyone in this room who would hire an attorney and keep them hired when the attorney never met with you, doesn't answer your phone calls, doesn't answer your emails, never works through the theory of the case until you're standing on the courthouse steps before you go into the courtroom. An attorney who will sit and present no witnesses because they don't have time. Even if you give them the names of the witnesses, they don't have time to interview them. They don't have time to verify that the witness is actually going to tell the truth when they come into court. They don't have the resources available to them to determine whether the Department for Children and Families affidavit got the family and the children into court, whether it's accurate or not. Because that requires an investigation. They don't have investigative resources other than they can ask for social service personnel on contract who are solo practitioners who don't actually work for them to assist them in doing the social services work that has to be done. Now, there are no bad people in this process. I've been doing this job for about 8 years. I've worked with roughly 2,500 Vermont families. I've met, well, Vermont parents. I've met a lot of lawyers. I've worked closely with a lot of lawyers. Some are really good. Some are really bad. Most of them are like us. They're somewhere in the middle. But none of them are doing this because they're bad people. They operate this way because this is the system that they've been given to operate in. If they want to practice this type of law, this is what they have to do. There are some attorneys who have a successful solo practice and will take a few of these cases at a time because they are so consuming. But there are other attorneys who can't manage multifaceted solo practice and specialize in this work. What we don't have in Vermont is we do not have, and we've never really had, except for 2 pilot projects, what's called an interdisciplinary team of people who provide legal representation for children and families. And what that means is a lawyer and a social services person who work together as a team, and more importantly, work together in a larger structure where they're provided with training, they're provided with support, where they have supervision. None of these attorneys are supervised. They're not. So we have a contract with attorneys, but nobody actually supervises the attorney for a couple of reasons. One is you can't supervise, a state employee can't supervise a non-state employee, and you can't have a non-state employee supervising state employees. So all of these individuals truly are individual solo practitioners. There are no performance measures. There are no standards that they have to follow other than their own professional standards. There is no consistently mandated training so that people are actually competent in doing the job. None of those things exist in this system. The Defender General's Office, to its credit, has tried to implement elements of this over time, but they simply haven't had the resources. They've never had the resources. And I will be frank again in this discussion. When I've talked with the judiciary, the problem is the legislature. You don't give them the money. When I talk with the legislature, the problem is the judiciary. It doesn't give us a plan as to how money would be spent. When you talk with the administration, it's not in the budget. Those conversations have been going on since 2018, and they're not going to stop until we actually do something with the bill. I want to give you, and I want to be clear about this. I sound really negative because this is a negative issue. This is an issue that needs to be fixed. And whenever I begin to feel like I'm getting really negative, I think back to something that happened to me once a long time ago, where an older gentleman asked me why I was so focused and negative about looking at problems. And I said to the president of the college at the time, you have a brand new Cadillac. And when you're driving down the highway and you have a flat and you get out of your car, what do? Do you stand on the highway and look at your Cadillac and say, wow, what a great car this is? Or do you get the spare tire out and the jack out and fix the tire? This is a fix the tire time, folks. This is not a we've got a great system here, because we don't. And the reason that it is not just focused on these attorneys is that they bring a critical element to family court. Without an effective legal representation, DCF has no one to provide a check and balance on their affidavits. They don't have anyone to actually verify that what they did was right or wrong, or to go back to them and say, hey, you made a mistake here. Oh, okay, you're right. You've proven to us. We'll fix that mistake. They don't have anyone to do that. The state's attorneys don't have anyone who will say to them, do you realize that DCF affidavit that you turned into a petition that brought this family into family court and removed that child was wrong? They were wrong on the facts. They were wrong on the witnesses. Had you had this information ahead of time, would you have signed that petition? And the answer is, well, no, not if I had that information, I wouldn't. All of this builds up to a judge who sits in family court who can only rely on the prosecutors and the legal representatives from the other side. That's what they have to make their decisions based on. And if they're only getting information from one side that isn't vetted, truly vetted, they can't make the decisions that are in the best interest of the child or the best interest of the family. So I just want to, I had this really nice presentation, and haven't worked out. But there are a couple things that I would like to read for you. And that is so that you have something of an understanding. Since BPRC was formed almost 16 years ago, the number one complaint that we've received is about the representation people get. And I take this with a grain of salt. Like, is this just sour grapes because the people weren't successful in court? So we have, and I have continued this process. We vet those complaints when people call us. We have a process of asking them questions. Did your attorney do this? Did they do that? And depending on their answers, we have a follow-up question so that we get a real sense that, you know what? Your attorney actually has done everything they're supposed to do. They really have. We understand this is frustrating for you, Mr. or Mrs. So-and-so, but your attorney is doing a good job based on what you have told me. Or, you're right, you're not getting effective representation. So here are the things that you can do to try to get your attorney to actually represent you. And while you're trying to get these things done, if they don't do them, you've now built a case to be able to go back to court and say you'd like a new attorney. It is very rare in child protection cases that go on for longer than 2 years for a parent to have the same attorney. A large number of parents wind up with 2. Fairly large number wind up with 3 or 4. None of whom are working for the same firms, each one who starts the whole process over again with them, and each one who's under exactly the same pressures that they were facing, that the previous attorneys were facing. I've had one client where I was working with who had 5 attorneys in 3 years. 3 of them he never met. Had another client that I've worked with whose attorney just disappeared, just left. Didn't tell anybody they were leaving, just left. And no one knew that the attorney had gone. It took months for it to finally come to surface that there was no attorney any longer. They were long gone. And then it took a couple months for that person to be assigned another attorney who started the process over. One of the main things that you will hear from a later witness is the fact that this is not only an interdisciplinary model that's being looked at, it is in fact a model that begins working with families before they go to family court. It's called pre-petition, pre-activities before a petition for family court for a CHINS is filed, as well as working with a family who does go to family court. Now, why is that important? And we do very, very little pre-petition work in Vermont. Again, because there's never been the money available. And quite frankly, I don't think that there was the knowledge and the understanding of how important and critical that is, how you can divert people very easily if you get to them in time. It's like medical treatment. The reason that one of the indicators that I believe for a system that fails in that respect is the termination of parental rights rate for a given state. Now, Vermont is typically ranked 1, 2, or 3 in the country for child well-being, best places to be for child well-being. There's also a ranking for the states that terminate parental rights based on children who are ages 0 to 3 per 10,000 children in the state. It may surprise you to know that Vermont has the distinction of being in the top 5 for the last 20 years. We terminate parental rights at a higher rate for very young children than 45 or more states every year. There's only one state that always outstrips us, and that is West Virginia. And I have wondered for a long time, how is it West Virginia is always number 1? And then I discovered yesterday, it took me 8 years to figure this out, that West Virginia has a statute that says that if you have your parental rights terminated for one child, it is automatic that they will be terminated for each successive child. That child, that's a TPR. It's automatic. It happens. You didn't have to go to court and try to get it undone. That's the reason West Virginia is so high. Our system doesn't purport to be that kind of system. We purport to be able to work with families from birth to death in one fashion or another. But we still find that we have such parents that we have to remove their children when they're really young. And 0 to 3 usually means the child moves into adoption. It's often what it means. The last thing that I will do here, because I know you're getting tired of hearing me, is just a very brief little story, but it's endemic. A retired judge agreed to sit in family court due to high caseloads, came out of retirement. When the first case was called, the judge asked who among the professionals in the courtroom had been with the case since the beginning. No one raised their hand. It's the 3-year-old case. No one in the courtroom other than the parents. The GAL had not been there. The state's attorney hadn't been there. The defense attorney hadn't been there. The DCF worker hadn't been there. No one had been there at the beginning of this case. The judge then asked where the child was placed, because the child was in DCF's custody. No one knew. Nobody knew where this child had been placed. The new DCF worker who was there had a file. The judge asked him to check the file. The worker checked the file and then gave the name of the foster parent that the child had been placed with. Because the judge had come in the day before and reviewed the case, he recognized that the foster parent who was now taking care of the child, first of all, no one knew that the child had been moved to this particular foster parent, was the original abuser. Now, how can this happen in a system? Mistakes happen all the time, but this is a systemic failure where a young child in a 3-year-old case in family court, no one knows anything about the kid. This system that you will hear described by later witnesses is in fact a system that precludes those kinds of mistakes. And then I would add really, and then I'm happy to take whatever questions you have. The federal government has offered states, and there are now, I believe, and I could get the number wrong, I believe that there are 16 states who are fully vetted in this program in the country. There are others who are doing it partially, and there are some who are just beginning. Is that there is a model, the interdisciplinary model, with all of the attributes that I described: supervision, training, et cetera, performance measures, adequate pay. If a state develops that kind of system and has a data system that can produce the data the feds want to see from the system, the feds will match general fund dollar for dollar. That's all you have to do. You just have to put the model in place and make it work and produce the data. The latest stumbling block in this process is that, as some of you may know, the DCF data system is antiquated. And Matthew, you may be able to correct me. Is Vermont the only state that doesn't have the CWIS system at this point? There's some others. Okay. So CWIS is the acronym for the data system the feds want. Well, we've been waiting for CWIS for a long time. And every year we wait for CWIS, we lose potentially $1.8 to $2 million every year because we cannot enter this program. One of the reasons for creating this work group is to find a workaround, because I don't believe that there is any issue that can't be fixed with a workaround as a temporary factor. And we ought to be able to come up with a way to go to the feds to say, look, we don't have CWIS, tell us what you want. And once we've defined that clearly, we'll go pick a group, Irish monks who are working in a monastery somewhere, with quill and ink to come and create the data for us so we can send it to the feds. There's nothing here that is impossible to do. We just haven't had a working structure to make it happen and a deadline by which it has to be done.
So let me ask you a
Okay.
question just on that.
Yep.
Very point. I'm looking at page 4 of the bill, line 20. Is that,
Oh, I'm sorry. I don't have the copy of the bill, but go ahead.
this is one of the parts of the report, a plan to use Title IV funds to support the proposals. Is that where this?
That's where this comes in. That's exactly what this is. The money that's the federal money, believe it or not, for all you hear about Social Security, is because Social Security pays for a lot of the child welfare services. It is the Social Security money that the federal government determined could be used for this purpose. It's
Okay, so
Title
this is
IV.
social, this is social. My next question was whether this funding is reliable, given what we've been hearing as far as cuts in funding level.
The quick answer is I don't have a direct line to Elon Musk, so I'm not sure. But the reality is, if Social Security isn't secured, nothing else is going to be secured. So it's as secure as it can
And
be.
you'll know as you're going through this.
We will know.
So,
Because if the money's not available, we would have to find another approach, and it might take us a long time to do that, but we would still have to find another approach because our current system is inefficient and ineffective, costing us a lot of trauma and a lot of money. Because we're not getting what we need to get out of the system. I'm sorry, this was.
no, I got it.
Oh, okay.
Other questions? Zach?
First, thank you for coming in today. I appreciate your testimony, and I can tell from your testimony that you are certainly a subject matter expert on this.
She is the subject.
Refer to the subject matter expert, but
Yes.
I appreciate you acknowledging that at the outset. But I just have a few questions. I think one, I mean, all the studies, I would love to have those included in the record just so that we can be able to refer back to them. Because it seems that they're very pertinent to this conversation. The question I have, and in your words, you're like, this has been studied to death. And so my question is, in all the studies that have been compiled thus far, are there relevant policy solutions that you would hope to implement from those studies?
She will be able to tell you what those are.
Okay, great. So I'm getting ahead of myself a little bit. One question is, how many cases a year typically are we talking about in this universe?
Matthew, help me out here. How many CHINS cases a year? There was about 1,400. Okay,
You just identify yourself.
Sorry, Matthew Bernstein, Child Youth and Family Advocate, just,
1,400 in Vermont.
I believe that is correct.
Okay. And then another question I have is, and you do have a copy of the bill in front of you.
Yeah.
It's okay if not, but I'm on page 4 as well. And looking at the timeline for the report itself. And so I'm looking at line 10, subsection E, and it says that the report shall be submitted with honor before December 15th of this year. I guess, well, and this is a broader question for the chair and for the committee of, we always come to the or else, right? Like what happens if the report isn't submitted? Then if you flip to the next page, and I'm looking at page 5, line 10, it says that the Chief Justice of the Supreme Court shall call the first meeting of the working group to occur on or before August 1st. So my thinking is if this committee is convened, not committee, but the working group is convened on August 1st and the deadline is December 15th, do you think that's a reasonable enough amount of time for you in the group to complete this work?
I would say if the legislature moves expeditiously and passes the bill, then the group could start working based on the day of passage.
Okay.
As Judge Zone mentioned before me, there is nothing that precludes the group from beginning to work sooner.
Right.
And I can't speak for everybody who's been identified on that group, but I know a number of the folks are ready to start working now.
That's great. But you feel that a deliverable could be achieved by December 15th, assuming this is passed expeditiously and work begins in earnest.
I think it could.
Okay. Thank you.
I mean, the problem has been timeline creep since 2018. This holds people's feet to the fire.
Yep. Thank you. Good. Yep, I'm good.
Anybody else? John and then Ian.
Why so many TPI?
I think that's a very hard question to answer.
Is it because of the representation? Well, no, they're scheduled, so it's not that.
Part of it is the representation, but part of it is the way the system is set up. So as an example, if DCF has reason to believe that a woman who is pregnant and is going to be delivering a child on a certain date poses a risk to the child, then DCF has traditionally waited until close to the due date. I can't explain why, that's just the way the department operated in the past. Which meant that they then typically had to file an emergency petition. At an emergency petition, what the judge sees is the DCF affidavit and a petition from the state's attorney based on that affidavit. The emergency hearing is held sometimes with less than a few hours notice in some cases. In other cases, you have 2 or 3 days notice, but they're usually filed close to weekends, which means whichever attorney is going to represent the child or the parent is not going to be an attorney that they're going to work with in the future. It's an attorney who is being assigned in that emergency to that particular event, that particular morning or evening, who hasn't, in many cases, seen the affidavit and has had no time to talk with the parents. So the problem is that you can get a very quick decision made on little information, not because there's anything nefarious going on, but because a judge is faced with a situation where he's told or she's told, this is an emergency, this is a newborn baby, and if we don't do something, something may happen. No one wants to carry that responsibility. So you find that child go into state custody, and then they start going down a road which becomes more and more difficult to get out of. And consequently, especially with very young children, there are many people who would like to adopt very young children. So that's my perspective. I'm sure there are other people with other perspectives. I've seen that play out numerous times in the 8 years or so that I've been doing this work. I've been involved several times in actually interceding and stopping the process by reaching out to a state's attorney and saying, no, wait, look, you need to hear the other side of this.
I guess I'm just wondering if there's something going on outside of the courtroom that's starting this process. It's sort of just systemic or
I don't know, but one of the beauties of this is once you have an organized system, then you have people who work. So it's not just any attorney who's called who comes in. It's somebody who knows what it is that's going to happen, knows what they can do to make sure that everyone's rights are protected.
Yeah, Ian, then Tom.
Thank you very much for your testimony. I have 2 questions, and briefly, I just want to speak to and appreciate your point on sort of accepting the status quo as sort of like, I know attorneys that work in this area, and I have had like a thought myself of like, wow, I can't believe this is like how this system works. And it can get really easy to just like, get in a place where you just sort of assume that this is how it's
supposed to be.
So I find that really compelling, and I have had that same thought. So I appreciate that. My questions are just 2 very briefly. One, so Chin's cases have an automatic appeal, right? Correct?
Well, the Chin's case goes through a process with multiple hearings.
Yep.
There are at least 4 major hearings that occur. It can end with either basically no merits being found or with a termination of parental rights. The termination of parental rights, and again, Matthew, correct me if I'm wrong, that can be appealed to the Supreme Court.
And
yes,
and the TPR has an automatic, they have an automatic right to an appeal.
They have an automatic right to an appeal. However, the appeal is on the record.
Yeah.
So if there's no record that's been developed through the course of the Chin's case, you don't have much of a chance to win an appeal.
And And so my question is, the Defender General's office does the same contracting with the audit, the TPR appeal?
I believe so.
Are
Yes.
you seeing the same issue at that level as you have described at the court level?
What I've,
Lower court?
what I've, what I've seen at that level has been limited, so I want my
Okay.
statement to be understood as limited. There seems to be an attorney at a time who handles all of those, or all the ones I've been familiar with, for TPRs. That's one person who is having to go back and go through volumes of material. I've often wondered how one person could really do that job. Now, I've had fairly extensive interaction with one person who did it for a number of years. I'm not sure he still does it. I know that he was very studious in his work. But what he would find is he just didn't have much to work with. That's the problem. You can't bring new evidence in to an appeal. It has to be what was presented. And if your attorney didn't present evidence, didn't present witnesses, you've got not much to appeal. So.
And then only other question, how do you feel about the language on page 2, line 13, shall be consistent, as opposed to shall be?
I have my own opinion about that, but I think that Susan Jacobs may have a more informed opinion because she has much more experience. I think that this language is fine because I think what it also does is it sets up guardrails, and the guardrails can work both ways. It keeps you from straying out. It also keeps other people from straying in and saying, why didn't you do it this way? Well, because our direction was to do it the following way. But Susan may have a better answer than that. I'm fine with it that way. I think here's the real reason I believe this language should stay. We need the federal money. If we come up with something that doesn't fly with the feds, we've wasted our time because we're not going to generate additional general fund.
So being consistent with the study of Chin's case processing will mean that your path to getting the federal money is clear? I don't think so.
No. Not that it's clear, but it is clearer as to what we need to do. But I think that Susan can answer that question better than I can.
Okay.
Back when I thought I had more hair, I was on Human Services. And we had, the bill that sticks out in my mind, we were rebuilding the mental health system, the hospital system. And there was a couple different issues in there where people came in and said there was timelines. We need this much time to get things done. And both times I had to come back in because they didn't have time to finish. And when Zach asked you about the timeline in the January 15th, you said, I think we can. I would rather have a date on there where you say, yes, we can.
I think that's a question for the Chief Justice.
Okay.
Because it's the Chief Justice who is really, in this bill, is charged with making sure this happens. And frankly, that was done purposefully because in the states where this has happened, it has often been the Chief Justice who has taken the lead.
I mean,
Susan Jacobs can also, I'm putting you on the spot, Susan.
So I mean,
Maybe Susan can say, yes, we can.
I mean, the other point is that if there's going to be legislation, you would have to have it by December 15th at the latest, if there's going to be legislation for next session. Although this, to me, doesn't seem to be a one session issue, frankly, but that's another reason why we have to do that. If there's anything that we need to do legislatively, I mean, you could have a little bit more time, but not a whole lot if you want it to be dealt with. So I didn't hear you convince us that we should have legislators on there.
Well, okay, it goes back to history. I mean, legislators have always been, this is in the olden days, folks. There were always legislators assigned to these types of things so that on the work group, there would be a link back to the legislature. You would have somebody in the room with the discussions, and then with discussions started moving in this direction or moving too far in that direction, could say, wait a minute, that's not going to fly, guys. And here's why. That's one part of it. The other part of it is that my experience has been that they became the subject matter experts within the legislature on that particular issue. So you had people who could talk to you as peers, and your questions to them aren't shaded by what organization are they from, et cetera, et cetera. It's okay, this is one of us who spent the time, put in the hours. And I know last year when we came with the substantiation reform bill, there never was a working group actually put together. There was one done informally, and there were legislators who were invited and participated. And that was a different scenario, but that's it. A lot of it is, I think, history, just as having two from the House and two from the Senate, so that you had the two major parties represented.
Not convinced, but that's a good.
I'm not trying to sway people one way or another.
I know.
And you guys have your own workload to deal with. And so, but I think that's really why it's there.
No, and yeah, I do understand that. All right, well, we have questions for Larry. Yeah, go ahead.
I just have one. The language in this bill, was it based off another bill that has worked its way through legislature somewhere else? Who authored a lot of the language, I guess?
It is almost identical to a bill that was written in 2018.
Okay. And no, that's helpful, right? Like that's what I'm curious about. Is there?
Yeah, I was asked by a member of the legislature and the Chief Justice if I could craft a bill based on what had been introduced in 2018. And that bill never really got a hearing. It was introduced in the Senate. So, but it was still in the file.
Yeah,
So
and I
just
updated if there was precedent, and it sounds like there is.
All right, thank you very much, Larry, and we'll
Thank you very much.
go to Susan Jacobs next.
Thank you, Larry. Thanks for putting me right on the spot.
Anytime.
You have all the
No.
answers according to Larry, so
No stress,
we have
right?
very high expectations here.
No pressure. First, I know I'm on Zoom, so I just want to make sure you can hear me.
Yes, we can, and thank
Okay.
you very much for being here, Susan. If you just identify yourself for the record and proceed.
Sure. My name is Susan Jacobs. I'm an attorney admitted in New York State rather. And I'm going to summarize my written submission that you have in front of you, and I'll be happy, of course, to take questions. And we'll try to respond to some of what the conversation has been thus far. I first want to thank you all for taking the time to hear the testimony today and my testimony, as well as everyone else's, and to consider what I think is a very important piece of legislation. First, let me tell you the reason I'm before you, besides Larry and I worked together on this a bit, is that I've spent the last 25 years working to improve the legal representation of parents and children in the child welfare system, or the CHIN system. First, I was an attorney for children, and then for parents. And when I was an attorney for parents, what was really clear to me was that I could not represent them only by myself, that the matters that came before the juvenile court, the family court, were so complicated by and involved with issues of poverty, mental illness, substance abuse, and other problems facing a family, that we really needed the support of social workers. And later, as we developed these models, the support of people with lived experience who could really inform, those of us who had not gone through this, what the process felt like and what was missing. So I was fortunate that in 2002, I was able to pull together, I don't want to say it was a study group, we called it a consortium, of people who were experts in law, social work, psychology, some of the kinds of people you've brought into this or mentioned in this bill. And we started the first interdisciplinary program for legal representation in the country that was freestanding. And I was its executive director for 13 years. That program is called the Center for Family Representation. It's referenced in the bill. I think it can be useful as an example. I think there are other programs as well, and I'll mention some of them. Not because I'm biased, but I just think that the experience that CFR had can be useful. Now that program serves 2,400 families and more than 150 employees, and my hair used to be black. I left as it was getting whiter. And with the attorneys that started that program and other programs, there is now a group in the country really centered around the American Bar Association's Center on Children and the Law, who have developed this model, and I'll describe it a little bit more. And it works. It's supported by research, and it does save money, but it also saves in human terms. Since CFR, I worked nationally and have worked as a consultant in California, in Oklahoma, in Ohio. I sit on the ABA steering committee directing the work. And just for your information, I live in Lincoln part of the year. I think that I want to just briefly hit on some of the aspects of the model. Larry hit on a lot of them. But one thing that's important, I think, somebody brought up, what is the problem? You know, why is this a problem? When children are subject to investigations and a child welfare process that might be dealt with in other ways, and there are unnecessary removals, the consequences are really dire as these children grow to adulthood. The unnecessary investigation can traumatize kids and deter families from seeking, essential services that they actually do need. When kids are removed, the data on children who grew up in foster care, this is nationally, by the way, as opposed to kids who were not removed but come from the same neighborhoods with perhaps the same challenges, the data is dire. As adults, they're more likely to live in poverty, have lower educational attainment. They're 2 to 4 times more likely to develop mental health or substance issues. And as adults, they're twice as likely to be convicted of violent crime. So you kind of know where that pipeline goes. So that's, in a sense, the problem that a lot of jurisdictions have looked to interdisciplinary models to help resolve. And as Larry said, these models involve lawyers and social workers, but importantly, a third party who are the parents or youth with lived experience. So it's really like a three-legged, I hate the three-legged stool thing, but there are 3 professionals generally serving families on these teams. There is rigorous research that has shown that the programs limit child welfare involvement. And the reference in the bill to the study, the Child and Family Study, was done in 2019. And it outlined differences in outcomes between families represented by multidisciplinary teams and by solo practitioners. And if Nate is there, I'm going to try to share my screen. Can we do that?
Yes, we can. One moment.
All right. This is a big challenge for me.
You should be a co-host now, so you'll be able to share.
Okay, let me see. Where do I find my share? Okay. Sharing screen. How about that? All right. You don't want to see my vacation pictures, but you do want to see. Okay, can you see the slide that says research findings?
Yep, yes.
Okay, just quickly. It's important to know that this was not just CFR's program. This is 4 other programs in New York City, almost 10,000 families that were studied with 18,000 children. And the results of the study showed that their children who entered foster care, no matter who they were represented by or their parents were represented, were looked at. And when the parents were represented by an interdisciplinary team, those kids spent nearly 4 fewer months in foster care. And of course, as you guys know, that means a lot less cost because of the cost of keeping kids in foster care. Importantly, the children who were removed were also, when it was possible for them to be reunified with their families, they were reunified 43% more often in the first year after their removal with a team representation than a solo practitioner. And I can tell you that one of the reasons for that is that the team approach encourages very early and very quick work with the family to get to the nub of the problem. It's often the case that a solo practitioner, and not through any fault of their own, has lots of cases and little time. And so the cases drag out and take a long time. And for children in foster care, that clock is really critical. And remember too, that they're not with their families a lot. We talk about visiting in foster care, but we calculated once that in the course of a year, at least in New York, parents were only entitled to visit their kids 24 hours, like 1 day in the course of a year, essentially. Okay, so the same study found that there were higher rates of kin placement. So if children couldn't go back to their parents, and certainly there are those situations, they were placed with relatives much more often, actually twice as often, again in the first year of a case. And in this work, the sooner you get this resolved, the better for the family and particularly for the children. The cost savings, I don't want to be, the cost savings in New York were $40 million a year for New York City. And of course, the scale of the numbers of kids in care here at that time was quite high. So you'd have to look at proportionally how many kids you have in care and what the costs are to figure out what that might look like in Vermont. Also importantly, the child safety factor was that families who were represented by teams had no more maltreatment allegations than families not represented by teams. And we looked at that because people sometimes criticize the work with social workers and say, oh, you're kind of like hiding what's going on and you're not going to really tell us, and those families are going to be at risk of harm. Apparently, based on this research, not true. Okay, Nate, I can stop sharing for right now if that's okay.
And we have a question for you as well, Susan.
Sure. Thank you, Chair. Susan, thanks for your testimony today. One question, if we're to extrapolate off the Gerber study, what do you predict the savings would be for the state of Vermont?
Well, that's what I just said. I cannot tell you that because I don't know the numbers of kids in care and the length of stay normally. I can tell you that if you wanted to just do something on the back of an envelope and look at what the costs of care are per month, and if you're saving, let's say, 4 months of care, you get some sense of what that might be. I will say that there's an economist, and I don't know the person's name, but I will get it for you, who has worked with Oklahoma and New Mexico recently in trying to come up with that calculus.
I think I'd be interested to see, I don't know if it's you or if it's one of the other witnesses, if they could provide that. I think it'd be interesting to kind of see what the implications would be for Vermonters, at the end of the day.
Right.
I think would be curious.
We'd need to, the study group, the task force, somebody would need to really dig down into the data, but you could certainly come up with a projection.
Yeah, and I guess Well, I guess this kind of brings me to the question of the study group. I mean, is that, I mean, it seems like, I mean, I've seen all the studies and the reports that Larry had on the table. You know, it seems like there's a lot of information out there. Do you, I guess, just not so much a concern, but just a question is, you know, would there be any duplicative work of all the great work that's already been done by the working group?
No, because I think again, the guidance and the guidelines, you've asked that, somebody asked that question. If the group is directed toward a certain body of research and study, then I don't think it's duplicative, because no one's saying, go ahead and do another study. I think, at least I read this language to be, take what's there and go off and do it in Vermont.
Sure. And I guess one question that came up during Larry's testimony that, you know, he mentioned that you would be the go-to person for the answer on is just thinking about, you know, actual policy recommendations. Because it seems like, you know, between yourself and Larry and, you know, the people here in the room that we have a lot of great subject matter experts on the topic. And I'm just curious in terms, and again, this isn't necessarily you, Susan, but I guess I'm curious about the approach of doing this working group versus really putting teeth behind a really robust piece of legislation that could tackle this right out at the outset.
I would not have an opinion about that because I'm not sure about the legislative process there in terms of time, as people, you know, raised. I think you're right to be asking whether could we just go to, if you're saying, could you just go to
Right.
Language from my perspective, yes, but I'm not
Right.
sure you'd have everyone coming along who were mentioned as important voices in this issue. So the state's attorneys folks, the department, you know,
Right.
you'd really want to make sure that folks agreed with what we're saying now. And I can't speak.
And I don't want to put words in your mouth, but it is what I'm hearing that you want to use the working group purpose could be to compel people to sit at the table to draft the legislation. Is that?
And tie them to the chair? No, I mean,
No, I'm not saying that flippantly. I am curious. Like, is that part of, like, are people not being helpful? And that's kind of what the purpose of this is to say, you know what, if you're not going to be helpful, then you're going to be mandated by the legislature to come to the table and we're going to find a solution one way or another.
I think Larry and others could speak to that because although I spend a lot of time in Vermont, it's not around the work, so I'm not that familiar. But I do want to say, because this was the related question was, is the legislation and our legislators necessary? And I think in other states, and I'll mention them in a minute, the legislature has been very important in encouraging, supporting, and being the reason that people do move things.
Sure.
So
thank you. I appreciate it. I appreciate your testimony.
Sure. So I was just going to briefly go through what some of the core concepts are. You've heard about the teams. I don't need to go through that. I do want to say, because this does come up sometimes again in folks who might not like what we're talking about as the potential system, that it's a very different practice from criminal defense. And as Larry mentioned, a lot of solo practitioners do both and kind of have to go from one to the other. But this is a specialized area of the law. I think some of you are familiar with that. And it's different than representing a client accused of a crime, because in family representation, if the client is the parent or the client is the child, the family is also very present as almost a client. And the advocacy and social work components that are needed to assess the family's situation and craft a path for them to move forward are different skills than are the kind of skills that are used in criminal defense. Criminal defense does work with social workers, obviously, and well. What I'm saying here is that the representation relies on other skills and other areas of law and policy that have to be part of the person's practice and aren't always in the current system. By the way, that's true around the country. I'm not saying that the solo practitioner system that you have in Vermont is unique in not meeting the needs of families. Another distinction from criminal law that Larry mentioned is that the pre-petition practice. And that's important because, and again, people have to be trained in this and have to understand the role of attorneys, social workers, and parent advocates. It was developed in recognition that it's possible to divert people from court filings. Here's another place where we have not monetized this nationally. I wish we had, but you can imagine saving court costs. And so what happens is once a investigation is begun, a family could qualify for pre-petition services. And if they're able to solve the problem that brought them in front of the child welfare system, they might be able to have a case closed, an investigation closed, and not find their way into court. There are references in my testimony to the American Bar Association and to the Family Justice Initiative, all of which lay out these components of and the attributes of high quality representation. One thing I just want to surface is the role of the parent advocate. And the social worker. The social worker assesses the needs, the service needs, and sometimes people say, well, why isn't that the department's responsibility? And the answer is because departments are often overwhelmed and have lots of cases. Clients are sometimes given sort of cookie cutter instructions. You know, go to this parenting class for toddlers, even though your kid is 13. So the idea of having a social worker on the parent's legal team is to craft services that work for that parent. In rural areas around the country, the social worker is also somebody who helps the attorney try to figure out where on earth are those services. And what do we do about transportation? You know, how can we be creative? Again, this is not usually what the attorney is doing and what the attorney is trained for. Parent advocates also are vital here because they build trust with the clients. They've walked in their shoes. They know what it's like to have your kid in foster care and not be able to visit over the holidays. And they're the people who are always on the other end of the phone or texting with clients at midnight saying, it's okay, you'll get through this. You know, or here's what we're going to do. We're going to call the foster mother and we're going to get a visit over Thanksgiving. Those are just critical pieces. What I'd like to do is now talk to you a little bit about other jurisdictions, but I want to pause and see if I'm hitting areas that you have questions on.
Any questions? Not right now.
Okay.
I have a couple, but I'll hold them for a bit.
Okay, so let's talk a little bit about what's happening in other parts of the country. Larry mentioned that there are 16 programs, or I actually haven't counted them up lately, but they're in different stages of development. So I wanted to highlight just a few. Colorado has a state office of parent and child rep, which is legislatively funded. And this is another reason, by the way, that it's important to have legislative buy-in or buy-up. I will talk a little bit about funding. I don't think that Title IV-E can support the entire system. So there are going to need to be some other areas of revenue looked at. That office in Colorado does get legislative support and they are in the executive budget. They provide training for lawyers and social workers, but they don't have their own lawyers and social workers. They work with contract lawyers. They do hire their own parent advocates and assign them to lawyers. And one of the things they've noticed is that because of the social workers supporting those contract lawyers, there has been more engagement in family meetings with the department. And importantly, to Larry's point about termination of parental rights, they've seen higher reunification rates and lower termination rates. So I think it's 2017, Colorado's termination rate was 23% of cases that had come in the door. In 2022, it was down to 15%. And the folks in that office would attribute that decline at least partially to having better representation and more comprehensive representation. And I agree with Larry quite a bit that a high TPR rate is an indicator of a problem, in the system. Washington State started in the early 2000s with pilot programs in 3 counties. They were supervised by a Central Office of Public Defense, which is a legislative funded agency. So the legislature created it. I mean, it existed before interdisciplinary practice. Attorneys and social workers are the legal team. They work closely with parent mentors. They initially piloted it, as I said, in 3 counties, but because the results showed a reduction in the time a kid got to a permanent situation, which could include adoption, by the way, but often included reunification, the legislature actually voted to increase the program, and it is now statewide. And to the point about data from other places, I can get those references for you. In Ohio, where I'm working and have been working for the last 3.5 years, the Supreme Court in 2021 used federal court improvement program funds and money from the Child Welfare Agency to award contracts to 6 counties in Ohio. Ohio has a county-based system. The pilots, the 6 counties are urban, some of them rural. Some are running programs out of public defender offices. Some are actually based in the juvenile court. Sorry, was that a question?
It was not, it's just coughing, Sue, sorry.
Oh, no, don't do that. Don't cough. Okay, I was about to share a screen about Ohio. So if we can go back there, go to share. Okay. In Ohio, there has been a research program since the beginning of the pilots in 2021. And that outside evaluator, who's the same outside evaluator who did the study in New York City, will be reporting on 4 years of data during 2025. But each year they've reported an interim data. And year 3's evaluation is about to be on their website. It'll be up in March. But I just wanted to point out some of their data. This is outcome data from all of the 6 pilots. There were a total of, over 3 years, a total of 375 families and 853 children served by 6 interdisciplinary representation programs, and they're all new programs. The demographics of those pilots are most of the clients were women, parents who are women, and most of them identify as white, and 29% are Black and African American. In let me see if I can get to this next slide. Yes. Again, the year 3 evaluation. So we're looking at 3 years of data, and it's not a complete 3 years, but it gives you a sense of what's happening in these programs. The pilots show really positive outcomes for families. You can see there that most of the cases, 2/3 of the cases are successfully resolved. That means children either weren't in foster care, or if they were, they went home to parents. If they didn't go home to parents, they went home to a kin, generally. 12% of the cases did result in filings. A number of these programs are pre-petition. And 17% were closed because clients simply didn't stay involved. Importantly, just like in the New York study, we're starting to see in Ohio that few parents wound up coming back into the child welfare system. Again, this is important in terms of the stability of families and the future of these kids not going into the pipeline we talked about, but also talks about money saved because there were fewer court cases. So you see subsequent referrals for CHIN's allocations are 13%, and children removed from the home after enrollment in the program, 11%. The evaluators are working to get data, which I hope we'll be able to show you by the end of March, but maybe not quite that soon, on county comparisons. You know, what does this look like compared to other kids who are involved in the CHIN system in other counties? Questions on those slides at all?
Ian. So I'm going to simplify this a little bit just to see if I understand it. Part of this program is essentially like pretrial diversion, but for a CHIN's proceeding.
Correct.
So yeah, with a potential federal funding stream.
Yes. But
what are we doing?
The feds, as Larry said, potential. That's
Don't be so excited. The working group needs to head to the. No, I apologize. I just wanted to. I thank you. It's helpful for me just to make sure I'm on the same page.
Yeah, I'm gonna answer a couple of those questions in a minute. But I just want to see anything else on this. Again, it's very preliminary, but it's a good indicator. Okay, we can stop sharing. How do I do that? Thank you.
There we go.
All right, so just quickly, I want to mention in terms of the pre-petition data, specifically Washington State has a program for serving pregnant and parenting mothers, parents of substance exposed infants. So they're at high risk for a child welfare filing. And between July 19 and November 2021, they served in this particular interdisciplinary program 123 clients, 85% of whom avoided any filing in court. So, you know, it's kind of it's stunning in a way, but it's also not rocket science. If you're serving people when they, you're meeting them where they are, you're providing a critical service, and you're well funded and you're well resourced, this can be the kind of data you see. I do want to turn to the funding questions. The programs we've talked about in other states are funded through a variety of sources. The Federal Court Improvement Program is one important source. I don't know how that plays out in Vermont, but in some states, like in Ohio, that's what really is funding these programs right now. Federal 4E reimbursement, obviously. 4E reimbursement, as Larry pointed out, is based on the state drawing down money from the feds. And the calculation on how much money you can draw down is based on what's called the state's penetration rate, which is a combination of how many kids you have in foster care and how many kids are candidates for foster care, which is almost any child in a family who has been touched by the department. And then they do a fraction of that. And folks there probably know that better than I. When Larry talked about the need for data for 4E, I think that's basically, Larry, what you were referring to. And there are other ways probably to access that than the Sequest system, to your point. But that would be something that a working group could outline and could look at other states to figure out what they do. In some states, Title E is definitely used for pre-petition representation. And that's in the language now from the Children's Bureau. Other states are just beginning to draw that down for pre-petition work, so I don't have those breakdowns. But there is a chart that I think I sent to you guys, to Nate, or to Larry, who may have forwarded to you, of the federal legal representation amounts by state from 4E. So for instance, in California has been able to draw down, a gigunda amount of money, like $61 million in fiscal 23. Massachusetts drew down $19 million in fiscal 23. I think because of the population differences, obviously Vermont's potential for that drawdown is less, but it's still, I think, significant for the system.
So Susan, I'm gonna have to do a time check because we're gonna have to go to the floor very shortly, and I know there were at least probably a couple questions. Can we?
Good. Let's go to the
I know
questions.
Zach asked some questions already, but I guess just so you're fine with this is on the page 2 line. This is Ian's question, but I'll ask it for him.
Okay.
Line 2, page line 15 on page 2. The working group's design shall be consistent with, as opposed to consider the recommendations.
Yeah, I think it's the guidelines, guide rail issue. I'm fine.
So so you're good with, you think be consistent with is better somehow?
I think it gives a little more direction, that's all.
Okay, all right, I think that's the main question that I wanted to make sure we had. That's that. So I will ask another question. This might not be for you, Susan. It may be for Larry. And this kind of reminds me, I was going to ask this and I forgot. And then Zach's questioning reminded me. So oftentimes we will, in a report, or when we form a group, one of the things we'll ask for coming back is, in fact, draft legislation. And we haven't done that here. And should we add that, or is there a reason? I mean, sometimes it's not appropriate. We're not quite ready and we need to kind of get a report back. But this seems to be on the cusp of whether it would help us if the group came back with draft legislation. Usually I think we are a little more definitive of what we want when we ask for that, but this seems to be right on the cusp of whether that would be something that the group could do effectively.
If the group was directed to do that, the group could do it.
Sure, but would that be the best use of the group's efforts, given where you are with it? You know this.
Well, I guess it comes down to, very quickly, the issue of it's not rocket science, it's paint by the numbers. I mean, the models are identified. It really is not a question of figuring out, are we going to build a new type of vehicle? It's how do we replicate what's already being done in other states? And I will add this other piece that I forgot to present. Susan was talking about the pilots and what their responses have been around the country. Between 2010 and 2014, BPRC ran 2 pilots with this model in 6 counties in Vermont.
Right.
And that
And I was CFR trained at one point trained folks on that model, so we know it's not new. So to stretch this out a little, it's not new, and there are the components of legislation, but again, that's not my, forte.
So, I mean, just very quickly, I mean, if VPRC has done work on this in pilots and models, that would be really helpful for us to see. I just think it's on the ground work that.
I'm not quite sure how to answer that because you're asking me to make policy, basically answer a policy question when the bill is really looking at Chief Justice leading a policy development group. But I mean,
But is that typical, Chair, for the Chief Justice to be directing policy from the judiciary?
He's.
Because if that's the goal of this,
Yeah, he's directing this.
but that's the stated outcome.
So it's interesting, yeah, the Chief Justice is a little bit different, but I don't take that as that different than, I mean, it is different, but then having the Chief Superior Judge, who often is kind of like the chair over different groups like this, but he usually will come in and say it's policy. It seems like they're just directing. Yes, that isn't something that is unusual, having the judicial branch have somebody at the table and often chairing something. So, all right. So, Bill, are you available tomorrow afternoon at 1 o'clock? Because we're not going to be able to get to you today.
Can you hear me?
Yeah.
Okay.
And just before you answer that, I just want to, before I lose any of my other members, we do have a witness in right after the floor, or 5-10 minutes after the floor. We're going to hear from Willa on H105, and we'll try to have a little discussion to see where we are on 105. So if you come back after the floor, we can